I'm Malcolm Skinner and I'm a solicitor in the LexisNexis PSL private client team. Today I'm joined by James Cook, a senior associate in the tax and estate planning team at Collyer Bristow, who will be discussing rectification of a will. Right, James, by way of background, can you briefly explain what you mean by rectification of a will?
Of course. Where a will fails to carry out a testator's intentions, the courts can offer a relief whereby they can rectify a will. This is served under Section 20 of the Administration of Justice Act 1982, and basically where a will fails to carry out the testator's instructions because of either one, a clerical error, or two, a failure to understand the testator's instructions, then the court has the authority to rectify that will. As a simple context of clerical error, a clerical error is really an error in the process of taking the instructions and drafting a will. A simple example would be where you include, where the testator wishes to include nieces and nephews within their will, and the practitioner fails to name them all. There is a little bit of caution there. You've got the difference between misunderstanding of law and also a clerical error. They're very different, and if you misunderstand the law, then that's potentially a negligence case. Now, when making a claim for rectification, the key is the deduction of the testator's intentions. And factors to consider when doing that are firstly the testator's intentions with regard to the specific clause or clauses in question, whether the will reflects the testator's intentions, and whether the practitioner preparing the will misunderstood those instructions, and in misunderstanding those instructions, that's the reason why the will failed to carry out the testator's instructions.
Okay, so what are the practical steps to make an application for rectification of a will?
Sure. Well, where the application is unopposed, this is dealt with within the family division, and then where it's opposed, this is a chance for the division application. For unopposed applications, this is made in connection with Rule 55 of the Non-Contentious Probate Rules 1987. And the applications must be supported by an affidavit setting out the grounds for the application, together with supporting evidence. Notices must be served on the parties that can be affected by the rectification and prejudiced by the rectification. Now, providing notices have been served and the application is unopposed, then the court can order that rectification. Now, if the court orders the rectification before the grant is issued, then the application for the grant must include an engrossment of the will in the form of a fiat copy. Although I would normally advise that if you are going to make an application before the issue of the grant, that you make a pre-lodgement inquiry with the probate registrar first. Now, where the grant has already been issued, the memorandum of the order is endorsed on the grant, and a copy of the rectified will is attached to it.
I take it there are time limits for making an application?
There are. In short, it's 6 months from the date of the grant, although the court does have some discretion to extend that time limit if the circumstances fit.
Okay. Rectification is, of course, an equitable remedy. Is there any recent case law that establishes what the court will do and its approach in rectification applications?
There is, and as you said, it's an equitable remedy, so it's very much governed by case law. In particular, the case of Marley v. Rawlins and another, 2014. Now, this is a clear illustration from the court, whereby they interpreted the classification of a clerical error and really extended the scope of its powers. So, as a background, the facts of the case in Marley, Mr. and Mrs. Rawlins wished to instruct a solicitor to prepare mirror wills. In doing that, Mr. and Mrs. Rawlins wanted to leave their estates to each other on the first death, making each other the sole executor. On the second death, they wanted to leave their estates to Mr. Marley, in this case, and he would be the sole executor and sole beneficiary. The instructing solicitor prepared the wills and oversaw the signing. However, when he oversaw the signing, there was a slight mix-up. When I say slight, there was quite a big mix-up, and Mr. and Mrs. Rawlins ended up signing each other's will. So on the second death, well, this only came to light on the second death. On the second death, Mr. Marley made an application to rectify the will, but this was opposed by Mr. and Mrs. Rawlins' estranged sons. And if this application was successful, then they would have been in line to inherit the free estate on the basis of the intestacy rules. Now, the High Courts and the Court of Appeal both ruled against the application on the basis that the will didn't meet Section 9 of the Wills Act 1837 for the creation formalities for creating a will. However, following further leave to appeal, the Supreme Court took a different interpretation, and they very much interpreted a will in the same context that they would interpret a commercial contract. So their primary concern here was the testator's intentions. And they didn't want to confine clerical error to what has been omitted or added to the will. So interpreting this, we can clearly see from Mr. and Mrs. Rawlins, their intention was to leave the estate as they first said, and it was just a simple error in the signing. So on that basis, they ordered the rectification of the will. Now, this case is particularly significant because it really does extend the scope of rectification, and rectification on the basis of a professional's error, which, as we know, the court isn't that inclined to do.
Not at all.
In contrast, we have the case of Reading and another v. Reading and others, 2015. Now, this diverted away from the broad brush approach in Mali. In context, really, the solicitor was instructed to prepare a will, and he used the firm's precedent will bank to do so. In preparing the will, the testator's intentions were to leave his estate to his stepchildren and children. So the solicitor prepared the will and used his precedent and used the term issue in the precedent.
Right.
However, in this context, the precedent didn't define issue to include stepchildren, and that was the issue here. Now, on true construction of the will, the court ruled that stepchildren should be included in issue. However, the court also looked at the point of rectification and ruled that this wasn't a clerical error, and in fact it was a misunderstanding of the law, and really was the solicitor's fault in the preparation of the will itself. So this is really a stark reminder to us practitioners that we're under a higher standard of care, really, in the court. The court puts us under higher scrutiny, and also when using our precedents, we've got to make sure that they're applicable and they're used in the correct method and correct form.
Indeed, indeed. So in the light of the cases that you've just mentioned, Mali and Reading, and the difficulties posed by rectification, what practical tips would you offer practitioners in this particular field?
Yes, well, it's very difficult because no one wants to rely on rectification. Rectification is very much a last resort, and we've got to make sure that we're best placed to ensure that such an application is successful. So really, rectification in the courts is subjective. It's interpreted subjectively by the court, and we're under a higher scrutiny than the layperson would be. So rectification by virtue of clerical error or failure to interpret or understand the testator's instructions can be very unpredictable within the court. So I think we follow our general best practices for the preparation of will, but in these particular cases, I think the key would be to ensure that we keep detailed, contemporaneous notes of all our meetings, our attendances, and clearly the instructions. We've got to make sure the instructions are clearly detailed, and we really try to keep to those as far as possible.
Very interesting.
Thank you.
That's lovely. Thank you very much.
Thank you.